Well, I have 11:31, so I think to be respectful of everyone's time, I think we should go ahead and get started. And folks who catch up with us in a few minutes will just miss my intro, so that's fine. So hello, everyone. Thank you so much for joining us this morning. We're really glad to be with you. My name is Sarah Mattson Dustin. I'm the Executive Director at New Hampshire Legal Assistance, and we're really happy to be presenting this webinar today, focusing on housing issues and unemployment insurance issues. We do want to make sure that we have room for your questions. If you have questions, please put them into the Q&A box that you can see at the bottom of your screen. We don't anticipate that we'll be able to get to all of the questions, but we'll try to get to as many as we can, and we'll also try to, if a lot of people are asking the same question, we'll try to bump those questions up so that we get the most popular questions answered for you. For those of you who aren't familiar with New Hampshire Legal Assistance, we are a nonprofit law firm. We serve the entire state. Our offices are in Berlin, Claremont, Concord, Manchester, and Portsmouth. We work with low-income people and older people, people age 60 and over, on civil legal issues that impact their basic needs. So we focus on keeping people safe from domestic violence or elder abuse, other kinds of abuse, helping people remain in their homes, helping people access economic security through income benefits, through access to health care. So that's what we do. We know that with us today are many of our partners working in human and social services agencies all over the state. We're really grateful for all of the work that you do for the client community that we all share together. You know, as we do, that we are in a time of extraordinary crisis, both a public health emergency and economic catastrophe. We at NHLA are seeing the beginnings of a surge in need for our services. We decided to focus on housing and unemployment insurance benefits today because we're seeing a particular uptick in requests for assistance with those kinds of cases. Our unemployment insurance cases really went through the roof right around the end of March, and we're just now starting to see a significant increase in requests for assistance with evictions. The data that we see from other agencies reflects there being a major need in those areas. That's why we focused in there. We would like for you to come away today with a deeper understanding of why you might refer a client for civil legal aid services, when is the right moment to do that, and how you can actually make that referral to us. So that's what we're hoping that you'll come away with knowing. And we're going to kick it right off by starting with the housing topic. So I'm very happy to introduce my colleague, Elliott Berry. Elliott is the co-director of our Housing Justice Project. He's also the managing attorney of our Manchester office. He is also the longest standing civil legal aid lawyer in the state. And he, if you have done any work around housing issues, you have almost certainly had the opportunity to meet or hear from Elliott. So I'm going to pass it over to you, Elliott, to start us on the housing topic.
Thank you for reminding me how old I am, Sarah. So just to start with the very basics. First thing, and I think you all know this, but it's just so important. If a tenant can't pay his or her rent, please have them apply to local welfare or the housing relief fund that is being administered by the community action program, especially the latter if there's any connection at all with between the non-payment and the COVID crisis in terms of loss of income or increased housing expenses. That is CAP housing relief fund should be the first place to go. Okay, next slide. So just going through the process very basically, if the tenant does not pay his or her rent, they'll receive a demand for rent and an eviction notice. These are both court forms found on the internet and the court website, but landlords can use their own as well. The next step is that once the tenant receives the eviction notice, the tenant has the right to what I call pay and stay. That is, pay the past due rent plus $15. But that right to pay and stay ends with the end of with the last date on the eviction notice. Normally it's 7 days, but under federal and state COVID-related regulations, in some cases, that's going to be extended to a 30-day notice. One thing that's really important to know is that the 30-day notice is limited to people whose non-payment occurred between March 17th and June 11th. And if it's federally assisted housing, then it would be between March 27th and July 25th. But legal aid can help figure all that out. So if the past due rent is not paid by the expiration date on the notice, on the eviction notice, the sheriff will deliver a landlord-tenant writ, which is a summons for the tenant to appear in court. When the tenant receives the landlord and tenant writ, they will see that on it there is a return date, and that's the date by which the tenant has to file an appearance form, which is the legal equivalent of asking for a hearing. But if you look at one of those forms, you'll see there's no box to say I want a hearing. Simply by filing the appearance, which is a simple thing to do, that's the equivalent of asking for the hearing. The hearing is normally scheduled between 7 to 14 days after the tenant files their appearance. I think under the COVID circumstances, it's often taking a little longer. The tenant has a right to a hearing, and again, they'll get it if they file the appearance on time. But normally, nothing's normal during COVID period. But generally speaking, it will be by telephone. If the tenant loses the hearing, they can ask for a discretionary stay of up to 90 days, which would be dependent on paying the rent as it comes due. They don't have to pay the past due rent, but they do have to pay the rent as it comes due during the discretionary stay period. Or they can file an appeal, which starts with the filing of a notice of intent to appeal, a very simple form in the court which held the hearing. But then within 30 days of the date of the clerk's notice of the decision of the trial court, a much more complicated document called a notice of appeal must be filed in the New Hampshire Supreme Court. And obviously we don't want to encourage tenants to do that on their own. And hopefully in many cases, NHLA will be able to help with that. So the thing that is most important is that tenants should be encouraged to call New Hampshire Legal Aid, that is LARC, or New Hampshire Legal Assistance, as soon as they get an eviction notice, but also anytime thereafter, when they get a landlord-tenant writ, when they get a scheduled hearing. The sooner they call, the better. But we do get cases on a regular basis in which we're able to handle it even when the tenant has already received the landlord and tenant writ. There are procedural problems that the Legal Advice and Referral Center identifies very, very well and can often help the tenant get the case dismissed on their own. And obviously, there are many other defenses against eviction, which we at New Hampshire Legal Assistance or pro bono attorneys can help with, and we do that every day. Again, I want to stress that all tenants should be advised by any of you out there that they are not legally required to leave their homes when the eviction notice expires. They can't be forced out until there's a court order, and they have a right to a hearing in court. And again, legal aid can help defend against all those sorts of evictions, and often we successfully negotiate with landlords to avoid the necessity of the hearing. And again, as I've started out, you just want to make absolutely certain that as soon as the tenant knows that he or she can't pay the rent, they should apply to the Community Action Program's Housing Relief Fund, unless there's simply no connection between their non-payment and a loss of income or increased expenses due to the COVID crisis. And in those cases, tenants should also be aware that they can and should call their local welfare office. Every municipality in the state is required to operate a local welfare program, and every municipality has a duty to relieve and maintain people who are poor and unable to support themselves, and that certainly includes people who are unable to pay their rent. And one thing that should be very clear is that a person does not have to have a residence in the town to which they're applying for local welfare assistance. Every person has a right to make a written application for local welfare and to receive a written decision. And you should call New Hampshire Legal Assistance right away if you're not given the opportunity to make an application, if you don't get a timely written decision, or your application is denied. Again, also, local welfare denials can also often be overturned by New Hampshire Legal Assistance, and many times that will result in a cancellation of the eviction, hopefully, and sometimes we'll have to go to court to defend the eviction. We've been known to go to court to force local welfare to provide the assistance that they're legally required to provide. It's a little random, but when you are dealing with a client who is thinking about withholding their rent, it is of utmost importance that you tell them not to do that until they talk to a lawyer and encourage them to call legal aid. And this tells you how to contact legal aid, and I believe the next slide will tell you how you can contact the community action agencies for the to access the Housing Relief Fund. Okay, I'd be happy to answer if this is the time for questions. I don't know if it is. I'd be happy to try to answer it.
So I'm monitoring the question box, and we did get one question which we also answered privately, but I wanted to share with everyone else as well. So the person who asked the question said that they're routinely making referrals for legal aid, but hear from families sometimes that they have a hard time getting through. So are there suggestions to help make sure that people can get access? So one thing that I'm really happy to share is that we just this week, through primarily the support of a CARES Act grant through the Nonprofit Emergency Relief Grant, actually have 5 new staff members joining us at NHLA, 2 paralegal advocates who will be with us on a permanent basis, and 3 temporary attorneys who will be with us through the end of the year. They are primarily focused on working with individual clients, so that doesn't necessarily make the phone any easier. We don't have phone hours at NHLA. Ours are open during our ordinary office hours from 8:30 to 5. We are generally able to get back to people, if not the same day they call, then within the first 24 hours. The central point for intake for civil legal aid in New Hampshire is the Legal Advice and Referral Center. Their telephone hours are in the morning from 9 to 1. If people are having a hard time getting through on the phone, If they have access to a computer, a smartphone, anything with an internet browser, the easiest way for them to apply without hanging on hold is nhlegalaid.org. You can submit. That website has not only a wealth of information that people can use to learn about their rights and to represent themselves, but also you can actually make an online application. And those applications, if they're the kinds of cases that we'll handle here at New Hampshire Legal Assistance, they're able to send them directly over to us. So that is one way that people can get through if waiting on the phone is a challenge. Through actually the consolidation of the phone hours, LARC is actually able to talk to more people more quickly now, which is great. They stay on the phones until they've cleared the calls for that day. And they have also gotten some CARES Act support to have additional intake staff during this surge in need. So, I am able to be upfront with you and say the demand for what we do is much, much bigger than the amount of resources that are available. But we do have some good news in terms of having some temporary increase in staffing that is going to allow us to respond to the surge in needs. So those are the tips that I'd like to provide about that. And I'm going to click back into the question box. So here I think is a question that we really want to answer. Is there still a moratorium?
Yes, there is no longer any moratorium, and a lot of confusion was created by the president's announcing his executive order that sounded like it was extending the federal moratorium. However, it simply directed federal agencies, including Housing and Urban Development, to consider whether a continuation or resumption of the moratorium should happen. I have heard nothing about any follow-up on that. So right now there is no eviction moratorium in New Hampshire.
Another question for you, Elliott. What happens if the landlord is selling the property? Are the tenant's rights any different, and can what happens if the landlord is trying to push the tenant into purchasing the home as opposed to continuing to rent it?
Yeah, so if the landlord is selling the property, there is no immediate effect on the tenant at all. What we see a lot of times is the landlord will bring in an eviction based on a 30-day eviction notice saying that they have good cause to evict, and that is that they want to sell the property and need the property to be vacant. And that is a grounds for eviction, but the tenant still has a right to a hearing on it. Sometimes that's a reason that's in fact a covering up some other reason. It could be discrimination, it could be a lot of things. But even if that's true, the tenant also has a right to go to court to try to get more time through the discretionary stay. So yes, if the landlord is really trying to sell the place, and it's especially if it's a single family home, it's very possible that an eviction will be ordered, but it may not be for quite a while.
Okay. Thanks, Elliott. We did get one just housekeeping question about whether this is being recorded. We are recording right now, and Sarah, can you give me a thumbs up if we're going to put it up line? Yes. Okay. My Q&A box was covering Sarah's face. Okay, so yes, for anyone that came in a little bit late, we will be making this available after we're done. So please keep the questions coming. We still have about 10 minutes or so. One participant has asked, what are landlords' responsibilities with respect to infestations of pests such as roaches or bed bugs?
So it gets a little bit complicated, but the simple answer is the landlords are required to do an assessment at least within 7 days of notification of a bed bug or any kind of insect infestation. After that, they can bill the tenant for the infestation if it's determined to be the tenant's fault. But two things about that. Number one, they can only bill the tenant for the remediation of the tenant's own apartment. And number two, if the tenant has to be at fault. And number three, the landlord has to offer a reasonable repayment agreement rather than requiring that the repayment be made all at once. If the tenant's not responsible, then the landlord again has to act quickly to do the remediation, and the tenant doesn't pay.
We're getting some great local welfare questions. The first is in two parts. First, what are the municipality's obligations when there is a household that requires assistance on an ongoing basis as opposed to in a one-off situation? And what happens if folks either don't have their receipts or are spending the income that they do have available on what the municipality is considered not basic needs?
Yeah, so let's try to, I'll take the first question. Actually, can you just repeat what I'm thinking about?
Sure. So I think that the participant is asking about what about a family that that requires assistance on.
Oh, right, ongoing. Yeah, I got it. Okay. Yeah. So the statute, which is a really old one, says that they have to relieve and maintain people who are unable to support themselves. What I think happens most of the time, and what should happen, is that the municipality will begin to provide the assistance, and over time, one of the requirements that they will do is to make sure that the family is doing everything that they can to find housing that is within their reach. And often welfare officers are very, very active in helping to make that happen. There really is no law right now that limits the number of months that a municipality has to help. They do have to make sure that there's a roof over the tenant's head. And then this, so the second one.
And the second question was about a scenario in which the client is unable to provide receipts or is spending the income that is available in a way that is perceived by the municipality to not be on basic needs.
Yeah, the key to both of those is that there really should be no preconditions, including the requirement for receipts, when the tenant first applies. But once the tenant becomes a recipient of local welfare assistance, the town can certainly require, number one, that they spend whatever money they do have only on basic needs, and number two, that they provide verification of how they expended the income that they do have. Local welfare assistance is always given by voucher, so it doesn't go to the tenant, but in terms of how the tenant spends their own money, they can be required to provide receipts.
Another local welfare question, and then we'll go back to a couple more related to housing. Residency. So what are the requirements in terms of how long a person has to have lived in a particular municipality? Do they have to have established residency in some way?
No, the statute is extremely clear. It says relieve and maintain, quote, whether or not they have residence in said town. There is no residency requirement. I mean, obviously the person, and we usually see this in terms of people who are homeless, is wherever they happen to be, they should apply. Even, let's say somebody who was recently living in Littleton, but ends up in Manchester because there was no shelter or whatever. In the first instance, they're gonna have to apply to Manchester, and if there is I think they call it an ethics agreement or an anti-dumping agreement between municipalities, where often for the first month or so, the town from which the applicant originally came from may reimburse the local welfare agency that actually provided the assistance, but that's not, that's not a state law. And the bottom line is that homeless person is entitled to relief and maintenance wherever they happen to be.
So this is a really interesting question, back to the housing topic. So what about a tenant who is perceived to have abandoned their apartment because they're receiving inpatient mental health treatment? As long as the payments were made in the meantime, is there a way to make sure that the tenancy is preserved, or if not, to remove the record of the eviction? Really interesting question.
Yeah, first of all, except in rare circumstances, if the tenant should not be evicted and should not be deemed to have abandoned a place if they're in treatment or rehabilitation somewhere. That shouldn't happen unless in some ways their absence is adversely affecting the landlord, which I think is pretty rare. And it's not unlikely that an eviction notice based on the fact that somebody is away for treatment could end up being deemed unlawful discrimination on the basis of disability. So, however, to move outside of the disability issue, the statute is very clear. There are a number of things that the landlord can do or that is required of a landlord before they can assume that the tenant has abandoned the premises. They're in the statute. I really don't want to take the time to go through them, but again, I think there are 2 out of about 7 or 8 factors that a landlord can rely on if they honestly believe that the tenant is no longer residing at the premise.
This may be our last question. We'll see if we can maybe fit 1 or 2 in after. What about tenants' property post-eviction? What rights do tenants have if, this question specifically mentioned a vehicle, but a vehicle or any other personal property is left behind? What are the tenants' rights?
Yeah, so generally for the tenant's personal property, the statute requires that the landlord keep the property and the personal property on the premises for 7 days and cannot charge for keeping it. However, after 7 days, the landlord can do whatever he or she wishes. So and that's 7 days from the date the tenant actually vacates, voluntarily or involuntarily. So people really have to be advised to hop on recovery of their property from their former premises very, very quickly.
I think we do have time for 1 more. So this will be our last question on the housing topic, and sorry to those we weren't able to get to. What happens in the scenario in which the eviction is not imminent? There is no imminent eviction, but a tenant has made a request for local welfare assistance. Is there any kind of trigger that has to happen before someone's eligible?
There is nothing in the law, and nor is there anything in any local guidelines that I've ever seen that says a tenant has to have an eviction notice before they're entitled to assistance from a local welfare agency. What the local welfare agency is supposed to do is do a budget sheet where they have a list of the tenant's expenses on one side, for all of the basics, and the tenant's income on the other. And if the tenant can't afford the rent, they're supposed to get assistance regardless of whether they have an eviction notice or not. And the last thing in the world you want to do is encourage people to get eviction notices in order to get assistance. And I should have mentioned before that, the right to pay and stay that I referred to earlier can only be exercised by a tenant 3 times in a 12-month period. So a policy that says no welfare assistance without an eviction notice is really setting up the tenant to get evicted down the road.
Well, thank you very much, Elliott, and thank you everyone for those great questions. We're going to shift to the unemployment insurance topic, and I'm happy to introduce my colleague, Ray Burke. Ray wears a lot of hats at NHLA. He is the co-director of our benefit project, as well as our energy and utility justice project. Ray has really wide-ranging knowledge about state, federal, and local benefits programs, as well as the world of utilities advocacy here in New Hampshire. So I'm going to hand it off to Ray, who will start our conversation about unemployment insurance.
Thanks, Sarah. Can everyone hear me okay? Okay, great. So good afternoon, everyone. So this is going to be just a general overview of how legal aid can help with unemployment. And so to start off with our first slide, we wanted to just make sure everyone knows that when in doubt, please recommend that people go ahead and submit an application similar to what Elliott was talking about earlier around some of the housing issues. There's been a lot of confusion since the pandemic started. With the passage of the CARES Act, there were some new unemployment programs created, and we've heard from clients that there's some misinformation out there about potential eligibility. So the main message is that a person can apply as soon as their employment circumstances have changed. And for some people, depending on which program they're going to be eligible for, the application date can be important and dictate when they can start receiving benefits. And so the earlier they apply, the sooner they can begin to receive benefits. The online application at Employment Security is available 24/7. So we encourage people to go that route if they can. Just a brief overview of the general rules. Again, with the new programs created by the CARES Act, there are some different rules for the different programs. But in general, Employment Security is going to make two determinations. The first is to determine if the applicant was working and what their earnings were over a certain period of time. This is generally referred to as the monetary requirements, or determining their financial eligibility. And then they're going to look at the reason the person lost their job and became unemployed. Generally speaking, applicants, claimants have to have been working and be currently unemployed through no fault of their own. During the pandemic, if the person lost their job or is working less because of the coronavirus, they may be eligible for either the traditional state unemployment benefit program or one of the new CARES Act programs. And this includes people who are self-employed. Or it also includes, importantly, a person who might have had their job offer rescinded as the result of the coronavirus. And along with that, it's important to know that people can appeal almost any action if they disagree with the determination that Employment Security has made. The most obvious examples are when someone has been denied benefits, or maybe they were receiving benefits and then their benefits are terminated because Employment Security has found that their situation has changed. Another example is when Employment Security has determined that someone is alleged to have had an overpayment of benefits. And unfortunately, we're seeing an uptick in overpayment determinations right now. We think partly because of some of the confusion around the new programs and some of the processes that have changed at different times along the way. There can be a quick turnaround for requesting an appeal, so people should act quickly to file a request. The deadline is usually 14 days from the date of the notice from Employment Security, and this is a much shorter time frame than what folks might be used to if you're familiar with other benefits, such as those administered by the Department of Health and Human Services. People can apply online, as we said, or over the phone to submit an application. But we really encourage people, like I said earlier, if they have the opportunity and access to the internet, that they should apply online, given the current call volumes that Employment Security is having to deal with. They've been able to staff up, you've probably seen in the news, but there still is a heavy volume, and so we strongly recommend applying online if the person can do that. When someone applies online, they're going to receive several notices after they apply, and it's important that they read all of those notices carefully and follow up with any additional information that might be needed. But there's two notices in particular that are important to keep an eye out for. One is, again, about that financial eligibility that we talked about, and that will often list what their earnings were over the applicable period of time, and will list what their weekly benefit amount is going to be. And then the second notice is a notice about their general eligibility for unemployment, and that, again, is going to be related to their reason for being unemployed and whether they meet those requirements. During the pandemic, there was a lot of confusion early on. I think right now, if people who are applying today, it should be a much smoother process. But some people are going to receive a separate set of notices because under the CARES Act, people can't receive some of the new CARES Act programs if they're eligible for traditional or state unemployment insurance benefits. So many people are going to potentially receive 2 rounds of notices about their eligibility for regular unemployment, and they may be denied, but then they're going to receive a separate round of notices related to one of the new CARES Act program. The most common one that you've probably heard of is Pandemic Unemployment Assistance, or PUA benefits. Again, the rules are slightly different for PUA, but which is actually why Employment Security is required to make a separate determination. But the law requires that those notices be sent, and folks have the same rights to appeal those determinations if they disagree. So if they're found ineligible for PUA benefits, they can file an appeal request to dispute that decision. If the person doesn't disagree, once they get those notices, of course, there's no action needed. But again, that appeal timeframe is 14 days, and they can submit that appeal online, by email, by fax, or by regular mail. We always recommend that people try to keep a record of anything they submit to Employment Security, but especially their appeal request. And if people have to file, if there's some reason that caused them to file the appeal late, they should still go ahead and try to submit that appeal, but they should state the reasons why they weren't able to appeal within the time frame. Those late appeal requests may be granted if the person can show good cause for submitting a late appeal. Next slide. So when should someone call legal aid? Here again are the most common examples that I referred to earlier. The most common issues we can help with are when people are denied benefits, again, either based on an initial application, or if they were receiving benefits and then received a termination notice that they're no longer able to receive benefits. They should call us right away when they get one of those notices, and importantly, take steps to protect their appeal rights, depending on where they are within that deadline. We can also potentially help someone when they've received a notice of overpayment, alleging that they've been overpaid benefits. We've seen, again, a lot of people around the confusion with the CARES Act and what those requirements are and what they need to show. So we have seen an increase in those cases, but there are potential legal remedies. And so people shouldn't hesitate to contact us if they get one of those notices. And the sooner they contact us, the better. Their legal options could be limited the longer they wait. And then we wanted to just highlight a few other instances where people could potentially benefit from having a legal aid advocate. The first one is around application barriers. Unfortunately, we don't have the resources to help people submit the applications, but we do want to hear from people and can potentially help them if they've faced challenges submitting those applications. So for example, we've heard from people who tried to call by phone and they weren't able to submit an application online. Phone was their only option. And then when they called, they were told by the Employment Security staff person that they were ineligible, and they received what we would refer to as a verbal denial. But when they called us, based on what they told us, we believed that they were eligible. And so it's really important that people be able to submit the application and get through any barriers they might face. The other one that we've heard about is when people have language access issues and may struggle obtaining interpreter services or translation services to be able to navigate the application process. And then early in the crisis, we saw a lot of, you probably heard about this in the news, a lot of delays. Many people had to wait a long time to receive their initial determination of eligibility. And even if they did receive that initial determination that said they were eligible, they had to wait, some folks, a long time for benefits to be paid. So hopefully these delays will be less common going forward, given the changes that employment security has made to its staffing and to the way it's processing and handling these applications. But we are still seeing occasional delays, and so people should still call legal aid if they're in that situation. Next slide. In general, people still have to be able and available to work to receive unemployment benefits. But we did want to highlight that, the rules have changed in a lot of ways. And so normally, for example, people have to show that they're actively searching for work. But during the state of emergency, right now, the work search requirements have been temporarily waived, but you still need to attest to the fact that you're able and available. So the easiest example is if someone has been hospitalized due to an illness, they would generally not be eligible to receive unemployment benefits during the time period that they're in the hospital because they were not able and available to work. However, what we're seeing a lot of confusion around is that there are situations, normally before the pandemic, if someone were to refuse to return to work or refuse a job offer, that would most likely disqualify them from receiving unemployment benefits. But things are a little different during the pandemic. So if someone is still able to certify that they had to refuse that job because of the coronavirus, they may still be eligible to receive benefits under one of the new CARES Act programs. So some of the common examples that we see right now is someone still can't work, couldn't return to work because they still don't have access to childcare. This is going to get potentially a little more complicated as schools and daycares begin to reopen, but it is still something we see a lot. The other one that's probably more common these days is someone is not able to work because their medical provider has told them that they're at high risk of complications from the coronavirus. So these are people who are immunocompromised, have underlying health conditions such as heart problems or asthma, or they may be at greater risk due to their age. Under the CARES Act, if folks were advised by a medical provider to self-quarantine due to their high risks, they could still be eligible for one of the new CARES Act programs, depending on the rest of the facts of their case and their situation. So we can help with questions around those. If someone was denied, even though they were told to self-quarantine, or if someone received an overpayment because they were alleged to have refused work or not been available for work. Those are a lot of the cases that we're seeing with and can provide assistance with. Next slide. Oh, sorry about my dog there. The one other thing we wanted to highlight is you probably heard about, and it's still in the press, one of the CARES Act programs provided an extra $600 per week in enhanced or supplemental unemployment insurance benefits. Those officially ended as of July 25th here in New Hampshire. And so during the time period when people were receiving those benefits, that extra $600 per week might have made them and their family ineligible for other assistance programs. For example, the most common example would be the Supplemental Nutrition Assistance Program, the SNAP program, formerly known as food stamps. That extra $600 per week counted as income and put a lot of people over the income limits for the SNAP program. So now that that program has ended, it's important to let people know that they should reapply for assistance if they're struggling to meet their basic needs, struggling to put food on the table. They should submit a new application for those benefits and perhaps other benefits they might be eligible for. There has been talk in the news about the president's executive order and Congress trying to reach an agreement. As of right now, there's still a lot of uncertainty around that, so we don't know what's going to happen. So it's important for people to act on what their situation is today. And as of today, those enhanced benefits are gone. And so if people need more help, they should reapply for those benefits. And we can help if they're denied. Similar to unemployment benefits, if someone's denied food stamps, Medicaid, cash assistance, or if their benefits are terminated, they could give us a call and we could evaluate their case and determine if there's a legal option for them to dispute that determination. And I think that brings us to the end. So similar to what Elliott mentioned, you contact us if someone is seeking assistance for an unemployment issue or another public benefit issue with another public benefit program. They contact us the same way at nhllegalaid.org or on the phone number listed there to call the Legal Advice and Referral Center. Again, we can't take every case and request for assistance that comes to us, but as Sarah mentioned earlier, we have tried to increase our capacity to be able to do more work going forward to address the increased need we're seeing out there. And if there are questions, we can take those now.
Thanks so much, Ray. I just wanted to highlight, particularly with respect to the unemployment insurance cases, we have trained a lot of attorneys in private practice over the past couple of months to handle unemployment insurance cases on a volunteer basis. That's a pro bono program at the New Hampshire Bar Association. So we have some increased capacity there too. So we do have several questions and I will see if we can get through them all. This is a really good procedural question to start. If someone was denied unemployment benefits but didn't appeal, can they reapply?
Yes, I mean, there's nothing preventing them from submitting a new application and reapplying. So the short answer is yes. I mean, you know, whether they'd have success really depends on the facts of the case. And but you know, if that denial was wrong, but they missed the appeal deadline, certainly reapplying would be the way to go.
Ray, can you explain again the difference between the pandemic unemployment assistance and the regular state unemployment insurance benefit? Yeah,
so there's a lot of differences. I think the main one to potentially highlight is that the pandemic unemployment assistance program was created for people who are not eligible for regular unemployment assistance. So the easiest example is say someone was had a short work history. So say they started working, you know, a week or a month before early March, before the state shut down and the governor issued the stay-at-home order. They would likely not be eligible for regular unemployment insurance because they wouldn't have a long enough work history to meet that monetary eligibility requirement. They wouldn't have enough earnings in what's called the base period. So typically, pre-CARES Act, they would be denied because they didn't have enough earnings. But under the CARES Act with pandemic unemployment insurance, even if they didn't have enough earnings in the base period, they could receive PUA benefits if they lost their job and were unemployed due to the coronavirus. So if the employer had to shut down because of the stay-at-home order, or if they lost childcare because their daycare or their school closed, even if they weren't eligible for regular or state unemployment insurance, they could potentially get PUA. There are some other differences, but I think that's the big takeaway, is that it's available for people who can't access regular unemployment benefits for some reason. And by the way, that's pretty broad. Even people who are serving a disqualification due to fraud, and that's the reason they can't get regular unemployment insurance benefits, they may still be eligible for PUA benefits under the CARES Act. So that's, I think, the big distinction, but there is a lot of differences in the rules, including how the weekly benefit amount is calculated. That's different between PUA and regular unemployment.
Thanks, Ray. Next unemployment insurance question. Could you talk a little bit about the eligibility for a parent who has a child who is medically fragile and advised by their provider to self-quarantine until a vaccine is available, meaning that the parent essentially has to quarantine along with the child? Any thoughts on that person?
Yeah, so you know, it always depends on the facts of the case, but just on that general hypothetical, I would say that person is eligible. If even if their daycare center is open or their school is open, but the medical provider has determined that it's too great a risk to the health of the child for that child to physically be at the daycare or the school, and the parent has to be home, has no other access, there's no other care available, I would say that person meets the eligibility requirements for the pandemic unemployment assistance program. So that person should certainly apply. If they've applied and been denied, they should give us a call. There's been a lot of I think challenges to administering the PUA program because people aren't sure. That there's a lot of confusing questions that people have to fill out, and those questions have changed over the last several months as Employment Security has updated their system to process these new programs. And so I think that created a lot of confusion early on. So that person should certainly apply.
So this next question is, could you give some examples of good cause?
So I assume this is good cause for filing a late appeal of unemployment benefits. I think generally you can think of it as good cause is something that was outside of the control of the person. So let's say, just off the top of my head, the Employment Security had their correct address, but the notice went to the wrong address. Sometimes we see instances where the date of the notice might be, say, August 12th, but the postmark date wasn't until August 18th. And so the person didn't get the letter until much later and caused them to miss the deadline. I would say that's good cause. If the person, even though this would get into general eligibility for those dates, if the person was in the hospital for something unexpected and missed the deadline, but felt they still could dispute the decision, I would say that should be good cause. But there's no specific examples in the law. It's kind of fact dependent on the circumstances, but again, generally situations that were out of the control of the individual.
Good. Here's a really important question. Are there income limits or other financial eligibility criteria for unemployment?
There are no income limits. Again, to be eligible for regular unemployment insurance benefits or the traditional program that existed before the pandemic, you do have to meet a certain threshold of earnings, as I mentioned, but there's no cap. The more your earnings, the larger weekly benefit amount you'd be eligible for if you met the baseline. But during the pandemic, if you don't have those earnings, as I said, you could still potentially be eligible for PUA benefits. There's a minimum benefit currently of $168 per week that people would be eligible for, even if they couldn't meet that minimum earnings threshold. So again, and it gets a little complicated determining what that threshold is. The law talks about a base period, and then there's an alternative base period. So I think the main message is I think clients should just apply. And then when they get the notice, they can review and make sure Employment Security is accurately accounting for all of their earnings. I think it would be difficult for a client to try to figure that out on their own beforehand. So I think when in doubt, just apply. The other thing to note about earnings during the pandemic is there have been some challenges and confusion around self-employed individuals who maybe weren't previously eligible for unemployment benefits. And under the CARES Act programs, their weekly benefit amount is supposed to be based on their net income or net earnings for 2019. And so there was a lot of challenges, I think, for people showing that, demonstrating that income. There was confusion about what was needed. And Employment Security is supposed to process the applications based on the information they have. But for self-employed individuals, if they think Employment Security got it wrong, they can always provide that income verification later, and Employment Security can correct it, even in some instances retroactive back to when they started receiving benefits.
A question came through in the chat that I thought it might be useful to pose. Has there been any limitation on benefits programs administered by the Department of Health and Human Services, so food stamps, TANF, in terms of benefits not being able to be terminated or reduced during the crisis?
At various times, there have been changes. I would refer folks to the DHHS website. They post those changes. I am not sure that off the top of my head I could speak to all the changes currently in all the different programs, but for a while, what I can say, the one big one is, generally speaking, in a lot of instances, DHHS was not terminating people from Medicaid coverage based on some of the changes that were made during the CARES Act program. And for a lot of programs, for a while, they were postponing redeterminations. I believe they are starting to do the redeterminations for some of those programs now. but there have been a lot of temporary changes made, and it's been different for the different programs depending on what flexibility the states have. Sometimes they have to ask permission to do those changes. Sometimes they have discretion. So I would refer people to the DHHS website, but there have been a lot of changes in many of the programs throughout the pandemic.
Another great question. How does an individual being eligible for Social Security disability insurance impact unemployment eligibility when a job was lost due to the pandemic? Great question. Intersection.
So the short answer is that, again, I always say it depends, and it depends on the facts of the situation. But in general, folks who are receiving SSDI and SSI can still apply for unemployment insurance benefits if they were working and lost their job, due to the pandemic. That is not a per se bar. So just because someone's receiving SSI or SSDI does not mean that they are automatically ineligible for unemployment benefits or the new PUA program or one of the other CARES Act programs.
Thanks, Ray. So we only have one pending question in a couple minutes. So if you want to get a couple more in, you're welcome to send them. The one pending question is whether there are financial eligibility criteria for assistance from New Hampshire Legal Assistance. So that's a great question. The answer is yes. So we are able to work with clients who have incomes up to 200% of the federal poverty guidelines for a household of that size. So the actual income limitation depends on whether it's a household of 1, 2, 3, 4, or more. We also do have some limitations on assets, but they're focused around liquid assets. So for example, if someone owns their home or owns a vehicle, that's not a financial bar to assistance from NHLA. For people who are age 60 and older, our financial eligibility limitations do not apply. We do continue to focus our resources on the older adults who are the most economically and socially vulnerable, but there's no bar to getting in the door for seniors in terms of income and assets. We also do, we do have the ability to occasionally waive those guidelines. So if there's a situation where, say, someone's at 202%, or someone has savings that they know they're going to spend the next week when they pay their rent, we do have flexibility around these guidelines. They're not totally rigid, but those in general are our financial eligibility guidelines. So one more question did pop in. How does a person receiving disability be able to get unemployment when there's a $1,000 earning cap per month? So I think that probably what the participant is trying to ask is for someone who's on SSI, how is the income from unemployment insurance treated? Do you want to take that question, Ray?
Sure, yeah. So if the question is someone's receiving SSI and then they were working part-time and then they lost that part-time job because of the pandemic, they would potentially be eligible for unemployment benefits. And the person is correct that if those unemployment insurance benefits put them over the income limit for the SSI program, then their SSI would be reduced to 0 or would be terminated during the time they're receiving unemployment insurance benefits, and they would have to reapply or reopen their SSI case with the Social Security Administration once the unemployment insurance, they've exhausted their unemployment insurance benefits and we're no longer receiving them. So depending on what their weekly benefit amount would be, and during the time when the extra $600 per week was in effect, basically anyone who was getting those extra benefits would have been over the income limit to receive SSI, and so their SSI benefits case would have been closed. If the question was different though, if the way I read the question though, Sarah, I don't know if this they meant is that if they were getting $1,000 per month in SSDI, does that somehow prohibit them? Was that how you, or do you,
I think you answered it and nothing has popped.
Okay.
Let's see, this will be our last question. How does eligibility work for seasonal employment? Can the unemployment insurance continue to pay after the season was scheduled to end, and would they be eligible if the seasonal employment ended early due to the pandemic?
Sorry, I'm just trying to look at the question to make sure I understood what it was. The answer is, and Sarah and Elliott, if you know, I'm going to ask you for assistance. There was some guidance put out about seasonal employment related to the new CARES Act programs, and I don't have that at the tip of my tongue. So I'm not sure how to answer that question. Sarah and Elliott, I'm not sure if you're familiar with seasonal employment, but I do know there's some guidance on it. So if there's a way to follow up with that person, we can certainly find out, but we have not seen any of those cases yet. And so I don't know the answer off the top of my head.
Okay. We finished being stumped by a tough question.
Yeah, I mean, certainly the part of the question I don't know is what happens once the seasonal employment was supposed to end. Certainly if they weren't working because of the pandemic during the season, they'd be eligible. My gut instinct says the guidance addresses what happens once the season ends, but I just don't want to speculate right now and cause confusion.
Well, we are at 12:32. Thank you so much to everyone for spending some time with us today. We hope this was useful to you. And again, we will get it up online for anyone that had to join late or leave early. I can tell from the questions that many of you are working in communities across New Hampshire trying to help people manage through this extraordinary crisis. So thank you so much for all the work that you do, for being great partners to us, and please hang in there. Thanks for joining us.